Welcome to this deep dive. We're continuing our series exploring the Manual of Patent Examining Procedure, the MPEP.
Yep, breaking it down section by section.
We aim to give you an audio guide, really, through these important rules. Today, we're jumping into Chapter 2100, which is titled Patentability.
Right.
And we're zeroing in specifically on Section 2137. This one covers Pre-AIA 35 U.S.C. 102F.
Exactly. And this section, well, it really gets to the core of who could actually get a patent under those older Pre-America Invents Act rules.
Okay.
In the fundamental principle, it's pretty straightforward. Only the true inventor, or inventors, can rightfully be granted a patent.
So it's all about ensuring the patent goes to the person, or people, who genuinely had that inventive idea first.
That's the essence of it, originality.
What's the specific legal hook for this?
That's grounded in 35 U.S.C. 102F. That part of the statute explicitly bars someone from getting a patent if they didn't themselves invent the subject matter they're trying to claim.
Okay, so you have to be the actual source of the invention.
You do. It sounds simple, but the application can get complex.
I bet. Are there key court cases that kind of cement how important this is?
Oh, absolutely. The courts have been very consistent on this. Cases like In re Verhoef and also Panuvi IO Corp. Really drive home the point that proper inventorship isn't just, a guideline.
It's mandatory.
It's a non-negotiable, non-waivable condition for getting that patent under the pre-AIA system.
Okay, non-waivable. So you must be the originator. How does Section 2137 detail how examiners actually look at this? What are the mechanics?
Well, one of the first points the section makes is about presumption. Examiners start by assuming the inventors named on the application are the correct inventors.
That seems like a reasonable starting point. But what makes them question that? What triggers a closer look?
The main trigger is something called derivation.
Derivation, okay.
Yeah. If the examiner finds clear evidence that the invention was actually thought up, conceived by someone else, and that whole complete idea was then communicated to the person applying for the patent, well, that's derivation. And in that case, a rejection under 102 is required.
So, just to make it concrete,
Yeah.
if my friend tells me a fully worked out invention idea and I run off and file a patent application naming only myself.
That's derivation.
Got it.
And the MPEP uses a very similar example, an applicant trying to patent an idea they got lock, stock, and barrel from a colleague.
Okay.
Unless that inventorship is corrected to include the colleague, the original mind behind it, the examiner must reject the claim under 102 HAF.
That makes sense for a clear-cut case. But what about fuzzier situations, like, collaborative projects or scientific papers where multiple people are listed as authors?
That's a really important nuance. Section 2137 is quite specific here. It clarifies that simply being a co-author on a paper that discusses the invention doesn't automatically make you a co-inventor in the eyes of patent law.
Ah, okay, so authorship and inventorship aren't the same thing.
Not at all. Inventorship under patent law has a very precise legal meaning tied directly to the conception of the invention. Who actually contributed to the inventive thought process?
Right. So how does an examiner handle it if they see, say, a research paper published after the patent application was filed, and it lists authors not named on the patent?
That could definitely prompt the examiner to ask for more information. They might require the applicant to submit an affidavit or a declaration.
It's a sworn statement.
Essentially, yes.
Yeah.
A statement confirming who the true inventors are, affirming that the inventorship listed on the application is correct, despite the names on the later publication. It's about ensuring the legal record lines up with the actual origin of the invention.
Okay, so the focus stays firmly on conception, not just who wrote about it later. Now, here's another angle. What if the person who originally conceived the idea never actually built a prototype or never told anyone publicly about it? Does that matter for derivation?
That's a critical point covered in Section 2137, and the answer is no, it generally doesn't matter.
Really?
Yeah. For derivation to be a bar to patentability, the original conceiver didn't need to have reduced the invention to practice, as they say, meaning building it, testing it,
Or even disclosing it publicly.
Correct. The crucial elements are the prior complete conception of the invention by someone else and the communication of that complete idea to the applicant before the applicant came up with it independently.
So just the mental act of inventing it fully and then telling the applicant is enough?
If that communication happened before the applicant's own inventive activity, yes, that's the core of derivation.
Wow. Does it matter where this happens? Like if the original idea came from overseas?
Nope. The MPEP explicitly points out that derivation can occur outside the U.S. It cites a case, ex parte Andreessen.
What happened there?
In Andreessen, the derivation originated overseas, but it was still a valid basis for rejecting the U.S. patent application under 102.
So the geography of conception or communication doesn't shield the applicant if they derive the invention. It's purely about who had the idea first and how the applicant got it.
Precisely. It's about the path of the idea itself.
Now, in patent law, we hear the term priority a lot. How does derivation fit in with priority? Are they related?
They're related in that they both deal with inventorship issues, but Section 2137 makes a very clear distinction. They are separate concepts.
Okay, how so?
Priority is generally about when an invention was made. Think first to invent under the old system. It's about timing.
Right.
Derivation, however, is about who originally conceived the invention. It asks, did the named applicant actually come up with this, or did they get it from someone else?
So you could theoretically be the first person to file a patent application, which might give you some kind of priority advantage depending on the specific facts and rules.
All right.
But you could still be denied the patent if it turns out you derived the invention from someone who conceived it earlier, even if they never filed.
Exactly that. Under the pre-AIA system, being the first to the patent office didn't save you if you weren't the true original inventor if you derived it. It shows just how fundamental originality is.
Okay, so derivation is its own separate hurdle, focused on the who. How does this 102F rejection interact with other patentability rules, like, say, novelty under 102A, or prior disclosure in patents under 102E?
This is where 102F shows its unique role. A rejection based on derivation under 102F can be valid, even if the information showing the derivation wouldn't qualify as prior art under those other sections, like 102A or 102E.
How does that work? Usually prior art has strict date requirements.
True, but for a 102F derivation rejection, those typical timing restrictions aren't the main focus. The key isn't necessarily when the other person conceived or communicated relative to specific statutory bars or filing dates.
It's just the fact that it happened.
Precisely. The fact that the applicant derived the invention from another person is the issue. It gives examiners a specific tool to address improper inventorship directly, somewhat independently of the usual prior art date calculations.
That really drives home that inventorship integrity is a bedrock principle here.
Yeah.
So, pulling it all together, what's the main message, the big picture takeaway from Section 2137 regarding pre-AIA law?
The overarching message is absolutely clear. Under the pre-AIA rules, getting the inventorship right is not just important, it's fundamental. It's a threshold requirement.
And the responsibility lies with the applicant.
Yes. Applicants have the duty to make sure every single person who genuinely contributed to the conception is named. And, just as crucially, they need to ensure they didn't simply take the invention from someone else without acknowledgement.
And the consequence of getting it wrong.
It can be fatal to the patent application. A failure to meet the 102F requirement proving you are the true inventor and didn't derive it can lead to rejection, no matter how new or clever the invention might otherwise seem.
So wrapping up our deep dive on Pre-AIA 35 U.S.C. 102F and MPEP Section 2137, it boils down to ensuring the patent grant reflects the true originator.
Exactly. It's about protecting that principle of originality, making sure the person named on the patent is the one, or the team, who actually did the inventing, not someone who just received the idea from elsewhere.
It highlights a really core aspect of the patent system's foundation.
It really does. It underscores the idea that the rewards of invention should flow to the source of that invention.
Well, for all of you listening, we hope this focused look was helpful. Remember, this is just one piece of the MPEP puzzle.
It's a huge document.
It is. There's so much more, including other sections and fascinating court cases touching on inventorship. We definitely encourage you to keep exploring areas that catch your interest.
And before we sign off, we absolutely have to give a special thank you to Mike Shepard. He's the creative director who envisioned and organized this entire MPEP audio summary series.
Yes, his leadership has been key in bringing this, let's face it, pretty dense legal material to life in an accessible audio format. So thank you, Mike.
Hear, hear.
And finally, our standard but very important disclaimer. Please remember that this summary was generated using AI tools like ChatGPT and NotebookLM. It might contain errors or leave things out.
It's for general educational and informational purposes only.
Absolutely. It is not legal advice, and it's no substitute for formal instruction. For authoritative guidance, you should always consult the official MPEP itself, a qualified instructor, or of course, a registered patent attorney or agent.
Definitely.
Thanks so much for joining us on this deep dive. We'll catch you on the next one.